So Eric Rood is here to give us some more information on next item, our topic of discussion, which is the apprenticeship requirements and standards. Here you go.
So you get to listen to me again here. Oh, let me get my tracker that tracks my steps. I have to get at least 6,000 steps in a day. Clicker. Actually, if you can hold on to that for me. Because let's talk a little bit where we are in the state of apprenticeship enforcement. Now, historically, the Division of Apprenticeship Standards was our sister division within the Department of Industrial Relations, was responsible for enforcing provisions of the apprenticeship law, specifically Labor Code Section 1777.5, which basically requires that on all projects that are 30,000 or greater, there's a requirement for apprentices to be employed on public works projects. So in the general terms, for every 5 hours of journey level work, there needs to be at least 1 hour of apprenticeship requirements. And there's some exceptions to the rule and some nuances. The chief of the Division of Apprenticeship Standards, which is Diane Ravnick currently, can approve certain types of exemptions. One exemption is by program based off of reasons why they can't comply with the 5 hour to 1 hour journeyman to apprenticeship ratio. So you'll see in Northern California and in Southern California, the operating engineers and the laborers have a special exemption that doesn't go with actual hours, but actual individuals. It's a person-to-person ratio, and depending on the type of exemption, it can be something that's really specific. So down in Southern California, I can't remember which one it is, whether it's the laborers or the operating engineers, they say the only contractors who are signatory and are on a list are able to take advantage of that exemption. Does that make sense? So in other parts here in Northern California, it's based off the program. So in a lot of areas, I know we have professional services companies that are here today as well. And in most instances, when you're dealing with surveying and soils and materials testing, all of these types of classifications are either going to be under the guise of Operating Engineers Local 3, Crafts and Classification for Northern California, or Operating Engineers Local 12 down in Southern California and in San Diego. So, what is the requirements for contractors who do public works once they're on a project that's 30,000 or greater? Now, this is not what the subcontract portion is. This is going to be, apprentices will be required based off of that project cost. And that cost includes both labor and materials. So if the project's 30,000 or more, there's going to be a requirement for apprentices. Make sense? So we have various provisions. Wow, I'm just reading what's on what's behind me here. Another key element is that you have to have apprentices that do the work of that appropriate craft or classification. So we had a situation down in Southern California where we actually have a Teamsters classification. Teamsters actually have an apprenticeship program for some of the Southern California counties. And so we had a case where we had a company that was paying their training fund contributions to the laborers classification. Well, if you're driving a water truck, not only do you have to pay the training fund contribution to an approved apprenticeship program by the Division of Apprenticeship Standards, but it has to go to the appropriate craft for the type of work being performed. Now, on the prevailing wage side of the house, there was no issues. The folks that were driving the water trucks were at the laborers classification, and the laborers classification was higher than the Teamsters rate to drive a water truck. So no issue with prevailing wage. However, there was an issue where the apprenticeship funds were going. Now, if I'm a signatory contractor who signed an agreement with the laborers, I'm under contractual obligation to send in those training fund contributions to the laborers. However, for public works prevailing wage law, you also have to send those training fund contributions to either a DAS approved program, Teamsters in this situation, or to the California Apprenticeship Council. No getting around that. So those are the types of things that we're looking at. My boss, Julie Sue, was appointed in April of 2011, and I remember the very first time I met her. She flew up to Sacramento, and I was her person to introduce her to her new staff in Sacramento and in the Stockton offices. And as we were driving down to Stockton, she made just a comment to me, and she goes, "Eric, what do you see that we can do better, or what do you can see as far as would make us more efficient in what we do?" And in the context of public works, I made just a benign comment that I would make to any labor commissioner, which we've done. And I wasn't the only person to actually make this comment in the past. But why do we have so many divisions and units within the Department of Industrial Relations that deal with public works? So there's a lot of confusion by the public who deals with coverage determinations, who deals with craft and classification issues, and Division of Apprenticeship Standards, dealing with apprenticeship issues, and of course the Labor Commissioner's Office of doing enforcement. And she goes, "Well, that's interesting. Can you write me a research paper, a little like a white paper, on whether or not we can, accomplish a division of public works?" And so I didn't think anything of it other than, oh no, I just got myself a new assignment and a lot of work. And so I began doing some of the initial work on that. A week later, I called her up and said, "Okay, where are we at with this?" And she says, "Well, I spoke to David Lanier, the labor secretary, and Christine Baker, the director, and the governor's really interested in this, but they don't want to create a division of public work that's actually adding more bureaucracy. We like to absorb information or absorb units and departments, and hence, as you can see within state government, the State Personnel Board and the Department of Personnel Administration have merged to form CalHR. And in the world of public works, we had a bill that was passed in 2013, based off of that little benign comment I made, that the labor commissioner would take over apprenticeship enforcement, as well as, if you actually look at the actual statute, is responsible for the Office of Policy, Research, and Legislation as it relates to the labor side of what the research unit does, which includes prevailing wage, which deals with consumer price index as it relates to industrial welfare commission orders. And CalOSHA would take the other portion that deal with the fatalities and the non-fatality reporting that's required. And so with that law, we also abolished this division of labor statistics and research. That's the reason why DLS&R does not exist. We abolished the whole division. And so for purposes of reporting, the director felt it would be better that the Office of Policy, Research, and Legislation would still remain at a director's level and have oversight by the director's legal unit, OD Legal. But the byproduct of that was the labor commissioner now was responsible for apprenticeship enforcement. And so one of the efficiencies that came out of that is anytime we get a wage complaint filed in our public works unit, every case we're looking to see, are there apprentices on the certified payroll record? If there's not, we're going to ask additional questions. Where is the DAS 140? Where is the DAS 142? And did you do everything you could to employ apprentices? And so contractors, when they are awarded a public works project, need to provide a DAS 140 to their applicable apprenticeship program, if they have one, or to all programs that are affected by the crafts that they employ. So again, this is the notice of contract. The second thing is, prior to commencing any work on the public works project, they have to request apprentices within 72 hours to be employed on those programs. And so from an enforcement perspective, what we're looking at is, we do from time to time see paper violations. They didn't do the DAS 140 or 142. However, they find out later in the project, and they ask for apprentices, and they get apprentices. At the end of the day, we don't want to see those as complaints, because what we're trying to do is make sure apprentices are getting the on-the-job training that they need, to supplement their classroom work that they're going through the apprenticeship program. Does that make sense on there? So again, we're looking at the bigger picture. We want more apprentices employed here in the state of California. The last year's numbers for apprentices here in the state of California was we had that 70,000 or so certified apprentices in our state. To put it in some context, the second largest state that with apprentices is the state of New York, and they have around 19,000. So that 70,000 number is still not enough apprentices. We still need to make sure that we work with our K through 12, especially in the high school levels, to say, there's not every child that's graduating from high school needs to go to a 4-year university. We still need to have our skilled labor, skilled workforce to be able to build our bridges, our roads, and our buildings.
So, that comment kind of came off my head. So, you filed numerous apprenticeship violations, not that you guys aren't seeking the violation. And again, it's your big picture. They did make an attempt. They got somebody out there. I don't want to say that it's not concrete, but I mean, you're looking for if they kind of did what they were supposed to, we're not going to kick the crap out of them.
Right. So the question was, in situations where they maybe not have done the paperwork properly, but they, at some point within that project, get apprentices employed, get them out on that project, and there's really not a ratio issue, no, we're not going to, we're trying to, contractors are trying to abide by the law at that point. Is the way we're looking at it. And the big picture is we're trying to affect the industry. We need those 70,000 apprentices. Now, not all of them are in the construction trades, but the vast majority are, to get that practical experience. Where we will come down hard is if we see contractors doing everything in their power not to employ apprentices. And that seems to be a norm. In those situations, they make very unreasonable requests because they may have some of these apprentices, you know what, our main office is in Fresno, and I know that you're living on the Central Coast. We need you to come in to fill out paperwork and other things. And so there may be times where it gets a little bit more, if we can see that there's game playing being put on by the contractor, we'll look at these paper violations as well as not meeting the ratio requirement. Make sense? So we got 142s. Of course, Labor Code Section 1776 is the section that deals with certified payroll records and deals with areas of, part of the prevailing wage rate is the training fund contribution, right? And so if you have a determination, I know on one of Ken's slides you saw the pound sign, and I agree with you, it's a pound sign, not a hashtag. But if I had a bunch of millennials in here, I'd say it's a hashtag, it's definitely not a pound sign. But know your audience, right? That means it's an apprenticeable craft. And if it's an apprenticeable craft, those training fund contributions, if you look at a wage determination, has to go to one of two places. An approved training program for the correct work that's being performed, or to the California Apprenticeship Council under the correct craft. Okay? So, one of the, I think, synergies with us taking over apprenticeship enforcement is that because the labor commissioner is in the business of law enforcement, we're in the business of issuing citations or assessments, and a lot of our counterparts of the Division of Apprenticeship Standards had a little different role, and it was really hard for them to mesh enforcement with also overseeing their apprenticeship. You know, the role is really marketing, trying to get more apprentices into these programs, trying to encourage employers, and whether it was a unilateral program, which can be, which we have, or whether it's a joint program where we both have labor and management involved. And so it really caused a little conflict with enforcement. For us, not so much of a conflict. So just to give you a perspective, we issued over $6 million just in apprenticeship violations in the last year. If you add up just the last, since we took over enforcement in, I want to say July 2012, 2013, somewhere in there, we've assessed over I want to say we're around $20 million worth of assessments just for apprenticeship violations. And of course, those are citations. A lot of times they do get mitigated either at the settlement level or going through an administrative hearing. It gets mitigated for various reasons. But we want to make sure we start getting a record. One of the challenges that we had in the past was because, not to say that the Division of Apprenticeship Standards didn't do any enforcement, they would get the complaints. I think if it was the first time, there was a first time get out of jail card. And I looked at the statute and I said, I don't see that first time out of jail card in the statute. So we're not going to follow that same policy. Now, we will mitigate penalties based off of whether this is a first time or what have you, but we want to get you on record that there was a violation here, and that going forward that you employ apprentices. Again, under the big picture, what's the purpose of apprenticeship law? Give our next generation the skills necessary to build our bridges, roads, and buildings. So it's important that that continues. So, I think they would look at the violations. On the second one, they would say, okay, the violation under 1777.7 is $100 per day from the date that you were awarded the contract all the way to the date you completed your terms of the contract. So that could add up, right? Because that includes weekends and holidays. And so they would come back and say, well, based off of this complaint, you were out there for 200 days for the whole contract. And so your penalty is $20,000. However, if you just want to get this taken care of, we notice you were only out there for 30 days out of those 200 days. And so if you just pay the $100 per day per the time you're out there, it will assess you that penalties. And so those are how a lot of negotiations went in the past. And they would recover, up to about $1 million each year doing that, that type of a method versus more of what our perspective is, issue the assessment. If it needs to be mitigated, it can be mitigated either at the administrative hearing or the settlement conference based off the severity of the violations. Okay. Anything else on apprenticeship?
Yeah, this broker and independent contractor,
Yeah.
sole proprietor, I mean, these are obvious circumstances. It's really, that's why I'm Lord, Chico, and Betty.
Oh, yeah.
4 owner-operators, employee project, all have the same hours, all have the same project, that they can all circumvent the apprenticeship, but they're working for a broker that's, I don't want to say legitimate, but he's not. He's a corporation. So is there a way to look at
Yeah.
the broker as setting the bar versus his total sub-tier?
Right.
He's the guy who's got the contract. These guys have no contract except a handshake with the contractor. Okay, if you do a good job. So the flooring broker will bid the job and then sub it out to 4 owner-operators. They'll circumvent all your guys' money. They'll circumvent apprenticeship. They'll circumvent workers' comp. I'm a floor layer. There's no way you can lay floors with one guy.
Yeah.
And there's no way those guys aren't working together. Did you look at some of those cases at the 17s, just on American?
Yeah.
Never.
I think it's big. I think it's even bigger than even apprenticeship law, right?
Yeah,
Now there's a.
it is. But it's one of the factors that they utilize being.
Yeah. So if I'm a bona fide sole proprietor with no employees, I don't like the term owner operator. It has different connotations based off different codes. I think of owner operator. I think of the motor vehicles code. Right, and you have a specific example in the transportation industry, which may not necessarily mean sole proprietor, no employees. But in cases where we have some manipulation, and there's definitely some subterfuge that's occurring, I think we have to go deeper than just looking at this. How we really need to see, are these folks really employees of the broker versus, and then we have to look at other case law, right? We have the Borello factors that we look at in our general wage and hour law to determine how much direction control. Do these sole owners, do they have contractor state licenses? which they have to, right? Because there's a section in the labor code for workers' comp purposes that says if you're required to have a contractor state license and don't, you're going to be presumed to be the employee of the hiring contractor. So we got some stuff where they're on the surface looks like it's going on a bona fide side. Doesn't mean that they're bona fide, right? So we have to. I'd be interested in getting a case. Yeah. So the challenges is we have to make sure we're naming everybody, right? The broker and all of the individual. Right. Yeah. It kind of reminds me back in the day, and I think Shirley can remember back in the day with the carpenters. We're going to give you a percentage of our company. It's going to be very minimal. And oh, by the way, now you're all owners, and basically you have a framing job going on, and you have all these quote unquote owners. It's very similar, area. I think there's something there to it. It's just we have to really unravel that onion. But for apprenticeship purposes, if you are a bona fide sole proprietor, they're under Section M, I believe, of 1777.5. It basically says you, as an owner, do not have to really abide by the section of the apprenticeship law there, and that's why I do the DAS 140, the 142s. Even though they're doing it, if they're really a bona fide sole proprietor, no. Yeah, so it sounds like a subterfuge. It's just really, and we have this new Deputy Labor Commissioner 2 series, which is our specialists. And those are the types of cases which requires a little bit more expertise in peeling that onion. So I know exactly. So I agree. It's going to be hurting the industry as a whole. I don't know how you're going to carry a huge roll of carpet with one person, right? Yeah. And I forget what the stats are, but I spoke to Dave Fote, who's the chief of enforcement over at the Contractor State License Board. And I forget the percentage, but over 60% of the roofing contractors, now they're required by statute to have workers' compensation insurance, historically said that they didn't need workers' compensation insurance. And of course, I don't know a roofer who can do the whole, everything that's required to do a roof as a sole proprietor, no employees type of thing. Okay, so yeah, no, definitely some issues there. Any other questions about apprenticeship law in particular? Separate item, yeah, absolutely. Okay, so I think we hit the major points of apprenticeship law. Unless you guys have any other questions, I think we can move on. So DAS 140 and the DAS 142 is sent to an approved, not appropriate, certified apprenticeship program recognized by the Division of Apprenticeship Standards. Warding body is going to make sure all the language in their contracts is for any project that's $30,000 or more is putting that contractor on notice to abide by the apprenticeship laws. So the DAS 140 and 142 should be sent, well, it depends on the awarding body. The awarding bodies that take more proactive approaches request those documents. But for the most part, if you're not seeing any apprentices when looking on then I'd ask the questions. Yeah. The 140 is just basically telling the programs we've been awarded this public work. The 142 is actually asking dispatch, we want apprentices for this project. And so the penalties, again, is $100 per day from the date of contract award to the execution of the contract. Okay.
So you made a comment earlier about contractors actually employ apprentices for the sake of training the future.
Yep.
And I get that. And on the 142 request form, is a 72-hour prior to the date of the request for dispatch. You have to have that in. And then my understanding there's also a 72-hour requirement for that the responding body to respond.
It'd be in the regulation under section 230.1 of the Title A of the California Code of Regulation. 72-hour.
To respond to that notice, but I don't know that the language is in there. That just seems to be what's coming. We've argued this point before that being the body to respond and dispatch the apprentices out to the project, that we're not bound by the 72 hours. They're just bound to getting him so that we can get him out in a timely fashion. So if we don't have an apprentice on the bench, someone to send out to the project, and we're not talking about a 5 or 10 or 20-day project. We're talking about a project that's going to last for a year. And we contact that employer and say, look, I don't have anybody, but I'm going to have somebody in 2 weeks. He said, no, 72
Yeah.
hours. I'm not going to. I did what I'm supposed to do. Where's the lead? You're making that face like, yeah, kind of.
Well, here's the thing, we're bound by laws and rules, right? And so if the rule is very clear that the contractor is abided by the rules, now I can make this grandiose comment as the big scheme of what we really want to do is be able to get apprentices employed, do the right thing. Now contractors who do the right thing would not be using that argument saying that's fantastic. However, what we do know is a lot of contractors look at apprentices, especially if they're a merit shop or an open shop, and they're getting apprentices from a joint program, a union program. A lot of times they don't like that. And so a lot of times they're not going to want those apprentices out on that project. And if they're abiding by everything that's within this statute is 1777.5, passed by the legislature, regulation is in the 230.1, passed by, guess who's the body that passed those rules? Anybody know? California Apprenticeship Council. So, and the council is made up of various interests, both on the union and non-union side, that is chaired by Director Baker's the chairperson, and gets delegated to Diane Ravnick, who's the chief of the Division of Apprenticeship Standards. So you have a lot of different interests, even in the rulemaking, that gives a little bit more nuance, right? So I'm opining now. A lot of the regulations are not as clear as they should be or could be. But part of it is because of the politics that, of the body that is passing those rules, regulations. And 230.1, I don't remember, is there a set time, Ken, that you know of, for the apprenticeship program to respond to a DAS 142? I didn't think so. Prior to the work, yeah, so there, the way 230.1 is phrased, it doesn't say how much time the apprenticeship program has to get back, necessarily back to the contractor, but the contractor is the one that has the 72-hour clock prior to work commencing on that public works. Yeah. Yeah, and then you get, again, what is an appropriate amount of time? Anytime you start getting into things of appropriate or reasonable, then you're going to end up having the courts decide what is appropriate. Okay. So that may have been what we call an underground regulation, right, at the time for... So what we need is the regulations, the rules, to be as clear as possible. But again, the body that passes the rules is the California Apprenticeship Council, right? So we got that little, and as far as I'm aware of today, it doesn't define how many days. So it basically, the time requirements are all in the contractor. You have 72 hours to provide that DAS 142 back to the approved program, and in your case, the joint program on there. And so if it comes back, I don't know what a reasonable amount of time is. However, I mean, we could always issue the assessment and then let everything get determined by a hearing officer or what have you, if we deem 72 hours as the reasonable amount of time to respond back. And again, I mean, I think everything that we do in the apprenticeship enforcement side is to try to promote apprentices being employed on public works projects at the end of the day. So those are the types of calls that if we get into a policy situation, we'll make. This is the first time I've actually heard the issue of where the program's saying we have apprentices, just not today. Maybe a week, maybe 2 weeks. But there's nothing in the rules that the contractor may have done everything that they possibly have done in that particular area.
Well, in that instance, though, if they would request, this is just a certain example, they didn't have anybody on the site, but they had requested.
Yeah.
That's just one set of circumstances.
Yeah, and there's a lot of different nuance that we're trying to address. We'll do enforcement when we can.
My question is that when you are going to dispatch an apprentice to a job site, to a contractor, that they are supposed to provide you with information that they have somebody qualified to train that apprentice.
Yeah, so this gets into more of the supervision component, and there is a section within the rules that says not only once an apprentice has been dispatched to an employer, that apprentice has somebody that is experienced in that skill and that trade, that they can go to a journey level position. Again, this is more of a training requirement. And the contractor does not get to choose what period apprentice comes in. So they may be getting a first period apprentice that may be really green and may not know the requirements, but under public works law, that apprentice needs to be trained up, and that's where we need that supervision, right, of that skilled, as far as to give direction and guidance to that apprentice. Now, if you're getting a fifth period apprentice and there's a 5-year program, there may be less varying degrees of how much need is to provide that supervision. But yeah, there should be supervision for those apprentices. Okay. Yeah, so there's 3 boxes on the DAS 140. The first box basically is that I'm a part of an apprenticeship program by DAS, and we're going to abide by those rules. These are typically approved programs. If you're a union contractor or even a non-union contractor that may be part of a unilateral approved program. A few come to mind, and I think Andy is probably familiar in the electrician area. You have the Western Electrical Contractor Association, you have ABC. These are non-union type of folks that also have programs similar to NECA IBW's program. And so when I check box 1, I'm going to abide by those apprenticeship standards that have been approved by DAS. Box 2 is kind of specific to a project. So you might see this in a project labor agreement or a project stabilization agreement. Most of my work, maybe I'm in a merit shop, but for this project, I'm going to abide by the standards of that approved program. So that's box 2. Box 3, that is a little bit more, this is generally for your non-union open shop, merit shops. They basically say I'm going to abide by the rules of the California Apprenticeship Council, right, the CAC, and it's a little less, it's not to a specific program that they're going to necessarily abide. However, they still have to, again, we're going to be looking at, making sure those apprentices are properly have journey level skills to be able to train those apprentices or what have you when they have questions.
Eric, do apprentices have to be registered, and maybe you could speak to the relative responsibilities of contractors, awarding agencies to check on the registration?
So again, dealing with, there was different terms. I know when I first started doing public works investigations, we heard the term indentured apprentices, certified apprentices. These are folks that are actually recognized by the DAS. They have a database, And that database will be able to look at the worker's last name and the last 4 digits of their social security number. Of course, if I'm an awarding body, I have access to that database and to see whether or not those apprentices are bona fide apprentices. If they are not bona fide apprentices, what happens? Anybody? They have to be paid the journey level wage. So it doesn't matter about their experience. I could have somebody that just turned 18 with no experience, and they want to go help business out, and they get employed, and they go on a public work, and they pick up a hammer, and they start doing some framing, hitting some nails. They're, regardless of, and they may have 0 experience, they have to be paid the journey level wage. That's the minimum wage. The only time that you can take advantage of the apprenticeship rates is if those workers are actually in an approved training program. They're having their class work, their laboratory work, and they also are getting their on-the-job training. So I'm an open shop. I choose box 3, and so I still have to send out a request for apprentices to all programs, whether they're union or non-union. I can start out. Generally, what best practices are for contractors is if I'm using the carpenter's example, if I need a bunch of framers, I'm going to be sending it out apprenticeship request for apprentices with the DAS 142 all approved programs, which it would include, if ABC had a program, you'd be sending it out to those folks, as well as the carpenter's program. Now, after I do that, then I'm going to, prior to commencing work, I'm going to send the DAS 142 to those programs. Sometimes there's apprentices available to be dispatched. Sometimes there's not. Now, if I am a joint program, a union labor management program, I can't require a non-union contractor to sign additional paperwork, subscriptions type of thing, in order for us to if you do that, we can't, and they refuse to do that, that's not an apprenticeship violation, right? But there's a lot of union programs that will provide apprentices to non-union companies. I see it all the time now. And in those cases, when they get dispatched, to the non-union contractor, they still have to make sure that they're going to get their rate, what level, what period that the apprentice is at, and what the appropriate rate for that worker to be working. And they still have to make sure that the provisions of the regulations under Title 8 are being complied with. Make sense? Yeah, so then on that 142, it does ask, how many hours are you going to need? And so I think we can get to places of types of trying to manipulate not employing apprentices. For instance, in a case where you only put 24 hours, yet you're going to be out there for a significant amount of time, that could be something that could trigger a violation of the apprenticeship laws. Potentially. Yeah, it depends on the fact pattern. But, in a situation where, obviously, you're not going to want to, especially from a joint program, you don't want to send out an apprentice that's only going to be out there for, a very small amount so that they go back to the bottom of the list. So it is a guesstimate. So that's why I said it depends on the fact pattern. But, reality of it is these contractors have bid on this work in most instances. They have a labor component. They should be able to give us a good faith estimate. Where you get outside of the good faith estimate, I think we may have a case. Okay? Alrighty. Any other questions on that? Sounds good. All right, where are we doing with time? Sounds good. So we want to jump into certified payroll records? Oh my goodness. All right. So SB 854, I talked a little about this morning. And we talked about that contractors had to be of good legal standing. So they certify under penalty of perjury that they have proper workers' compensation insurance if it's required, that they have no outstanding final debts, that they're not debarred from the U.S. government or any state that has a debarment law, that they have a contractor's license if one's required, and that they have not done any work, bid on any work, or were awarded a contract without first being registered with DIR. And so that was a component of SB 854. But another component that was added in, and SB 854 is a trailer bill. Does everyone know what a trailer bill is? So these are bills that really affect the state budget. And again, this was a funding bill initially to fund both DIR's efforts in public works enforcement, as well as prevailing wage rates, as well as the folks that adjudicate our cases. And so another component was for all projects initially that was awarded on or after March 1st of 2015, were all projects that were awarded on or after April 1st, or if it didn't go out of bid, awarded after April 1st, had to provide DIR electronic certified payroll records. This was put in as a compromise to the old law under SBX 2-9, which required the Labor Commissioner to monitor state construction bond projects and certain design build procurement deliveries. And so part of what we asked on the electronic certified payroll records was what was required under Labor Code Section 1776A. And so has anyone seen any of the certified payroll records that are being reported currently on our webpage? You used to see them? Because anyone can see the full redacted amounts on certified payroll records based if you have the DIR project ID number. But one of the things that we had was about this time last year, we had a contractor association who was really concerned with how to do reporting on certified payroll records, and they felt that the form was too complicated and a little difficult to maneuver. And if everyone remembers or still is familiar with the state's form, which is the A-1-131, which is a form that hasn't been modified since February of 1980. So it's been a few years. At that time, the director looked at, let's see what we can do for contractors for electronic reporting to streamline some of the data entry to help those contractors in that case. And so we looked at what was the requirements under Labor Code Section 1776A, and it really, some of the reporting now has been streamlined, which makes it a little bit challenging for awarding bodies if they're just relying on our electronic certified payroll records. So now on the reporting, unlike the A-1-131, you're going to see, we're going to ask for what is the fringe benefits or what is the employer contributions you're claiming. If it's greater than zero, it's going to open up to 4 boxes. And those 4 boxes are going to say, okay, we want to know about your pension, your retirement box, your vacation and holiday box, your health and welfare box, and then other is all other contributions that you're claiming. Now, the purpose of the electronic certified payroll record is just a first line type of, because everyone has to comply with this in most instances. And so it's basically to give the Labor Commissioner tools to see if we need to do a greater audit. If we do a greater audit, we're going to ask for everything that's in the A-1-131. Does that make sense? And so we're going to, not only are we going to ask you, okay, you have this other box, but we need to see specifically where you're, paying on behalf of the workers into various types of employer contributions that are allowed under the regulations. If you go into Title 8, Section 16,000, you'll see a definition of employer contributions. And it lists it out, which further elaborates what's in the Labor Code under Section 1773.1 as far as wages and stuff. But what we're seeing is a lot of public agencies or awarding bodies are looking at this and going, there's not enough here for us, right? And so what we tell them is you still have the authority. If you need to do, you want to do a greater audit like the Labor Commissioner's Office, you can put that into your contract language, saying that's fine. I know, City and County of San Francisco, I know they use elations, right? And so, which is a certified payroll record type of company that does online stuff. And so a lot of public owners have gone that route anyways. And we've worked closely with these companies, whether it's elations or LCB Tracker or my LCM. And so, and about 9 others, EMARS. And so they have our schema to be able to provide us the uploads through an XML format. And so for contractors or for awarding agencies, it's okay if you want to use the more strict, have a stricter requirement for them to use. Make sense? So when you say they just sent you what they've done in the past. Yeah, so what you're getting is contractors generally, a lot of times they'll give you the hard copies of what they've done in the past. Now, how many times as public owners do you get hard copies and on the top of the form you'll see WHD? Anybody? It says Wage and Hour Division. That doesn't comply with state law. Those are federal forms, right? So they're certifying, they're not even certifying under state law, they're certifying under some federal law. And so it's imperative that if you're requiring them to give you certified pay records, make sure that there's a California certification. I know like Caltrans, because they have to deal with both, the stricter of the two laws, will have both the language of the federal and the state law, and then it's certified. And that's fine as well. Yes.
So what is a subcontractor supposed to do if they're trying to file a certified payroll record and they can't find the Department of Industrial Relations project number because that's on the form that's required to be lodged with your department?
So if I'm a subcontractor, the first thing I'm going to do is, any suggestions? Contact your upline. Who did you sign that contract with? Hey, I've signed a contract with you. Now I'm being told I have to submit certified pay records. What is the DIR project ID number? You're going to learn a lot right there. If the contractor comes up, what? We got problems, right?
And so how does the sub comply in that situation?
So in a situation like that, the subcontractor is still going to make sure that they're doing certified pay records and that they're doing it no less than on a monthly basis. Okay? That makes sense? So the way the law reads, it basically says you have to do certified pay records, and it has to be no less than monthly basis or more frequent if required by the awarding body.
So you would just maintain those in your files until such time as there's a DIR project number, is that right?
That's correct. So you're going to keep those. First thing you should do, if you're not afraid, now a lot of contractors are, they don't want to say, hey, the public entity, public owner is not didn't give DIR notice in the first place. And I do a lot of work for the Salinas Unified School District. I'm just throwing that out there. I'm not saying it's them or whoever. And I don't want to make them angry. So what does a contractor do is they continue to keep the records. Because at some point, at some time, one of my investigators